Welcome to Employment Law This Week. I'm George Whipple. Our top story, what's on the agenda? The EEOC, NLRB, and DOL have published their spring 2018 regulatory agendas, giving some indication on the priorities for each agency. The NLRB wants to take on the continuing question of how to determine joint employer status, noting that it may engage in rulemaking to set a new standard. The EEOC identified 7 different priorities, including employee incentives for workplace wellness programs. And the DOL's agenda included proposed rulemaking on the salary threshold for white-collar overtime exemptions and a final rule to rescind the persuader rule. David Garland has more.
I'd say there are 2 surprising items in this agenda. The first comes from the Department of Labor with regard to the proposed overtime rules, the new proposed rules. Those have been the subject of some attention for some time, going back now to the Obama administration, and they were the subject of litigation. We expected the Trump administration to be acting sooner than it has in that area, and now this agenda tells us not to expect any additional proposed rulemaking until January of 2019. The second surprising area comes from the National Labor Relations Board. Again, particularly with regard to the joint employer standard. The board over the last few years and the past 2 administrations has addressed that standard in decision making, whether it's the Browning-Ferris decision or subsequently the Hybrid decision. Now the board is telling us, rather than engaging in the process in that fashion, it's going to consider establishing the joint employer standard through rulemaking. So that's a bit surprising.
More news from the EEOC this week in response to Me Too. The agency has published an article on preventing workplace harassment in its quarterly publication, Digest of Equal Opportunity Law. The article identifies best practices, including training supervisors and implementing a harassment complaint system, and contains specific content recommendations for harassment policies. The recommendations come out of a 2016 task force report addressing workplace harassment. The Ninth Circuit rules that evidence need not be admissible to support class certification. A Ninth Circuit panel reversed a federal district court decision refusing to certify a class action in a wage-hour matter on the grounds that the relevant evidence was not admissible. The Ninth Circuit held that courts cannot decline to consider evidence solely because it is inadmissible at trial. A salary history ban in Philadelphia? A federal judge says, not so fast. The federal district court has issued a preliminary injunction halting certain provisions of the law, which prohibits employer questions about a candidate's past wages. The judge found that the ban on such inquiries probably violates the First Amendment. The ruling did not impact other key provisions of the law that prevent employers from using salary history to determine compensation. Finally, it's time for our tip of the week. Tracy Van Dusten, Senior Recruiter and Account Manager for NRI Staffing, is here with some advice on hiring for behavioral style and cultural fit.
Are you still asking the old cliche interview questions? What's your greatest strength and what's your greatest weakness? Candidates are ready for these questions and often answer with, my area of development is actually a strength, or I'm a perfectionist. To overcome this hurdle, consider asking behavioral interview questions. Not only will behavioral interview questions help you identify high-performing candidates quickly, they will also give you insight on how adaptable they are, how well they collaborate, and what leadership and growth potential traits they possess. When asking behavioral interview questions, listen closely for STAR answers. STAR is an acronym for situation, task, action, and result. STAR answers will describe the specific situation, what the task or goal was that was being worked towards, will describe the actions taken to address the situation, and the results achieved.
Thanks, Tracy. For some example behavioral interview questions, watch Tracy's extended interview on the EBG Law YouTube page. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.